You're sitting in the back of a patrol car. Your hands are behind your back, metal is biting into your wrists, and your mind is racing through one single question: what happens now? Most people have never thought about this moment until it's actually happening to them, and in that moment, panic takes over. But here's the thing almost nobody tells you. The next 72 hours after an arrest follow a very specific legal process, one with rules, deadlines, and protections built directly into the Constitution. And if you don't understand how it works, you can accidentally make choices that hurt you for years. So today, we're walking through exactly what happens after someone is arrested in the United States, step by step, from the moment those handcuffs click shut to the moment a case either gets resolved or heads to trial. And I promise you, there are a few twists in this process that surprise almost everyone, including things police are legally required to do that they often don't explain out loud. Let's start at the very beginning, because the first few minutes after an arrest matter more than people realize. The moment you are placed under arrest, you are in what the law calls custody. That single word changes everything. Once you're in custody and officers want to ask you questions designed to get incriminating answers, they're supposed to read you your rights, famously known as a Miranda warning. This comes from the 1966 Supreme Court case Miranda versus Arizona, and it's the reason you've heard the phrase, "you have the right to remain silent," 1,000 times in movies. But here's the twist almost nobody catches. Police are not legally required to read you your rights the second they arrest you. Miranda only kicks in once two things are both true: you're in custody and they're about to interrogate you. If they arrest you and just book you without asking questions, they don't have to say a word. And if they do ask questions without reading you your rights first, in most cases, anything you say can't be used against them in court. Notice I said against them, not against you. Stay with me, because that mistake trips up more people than you'd expect. Once you're placed under arrest, officers will typically transport you to a police station or jail for what's called booking. This is the administrative part most people picture when they think of an arrest: fingerprints, a mugshot, and officers logging your personal information into the system. During booking, you'll usually be asked basic identifying questions like your name, address, and date of birth. Answering those isn't the same as answering questions about the alleged crime, and providing basic identifying information is generally required and doesn't violate your right to remain silent. Now, here's where the tension starts to build, because this is the part where a lot of people make a critical mistake. After you're in custody, officers may try to talk to you, sometimes casually, sometimes not. And this is where remembering your right to remain silent becomes crucial. The Fifth Amendment protects you from being forced to incriminate yourself, but simply staying quiet isn't always enough. Courts have said that in some situations, you actually need to clearly state that you are invoking your right to remain silent, rather than just going silent and hoping that's understood. This came from a 2010 Supreme Court case, Burgess versus Tompkins, and it surprises a lot of people because it flips the assumption that silence automatically protects you. So if you're ever in that situation, the safest and clearest thing to say is simple: I am invoking my right to remain silent, and I want a lawyer. That sentence alone does more legal work than staying quiet and hoping for the best. Now, after booking, the next major event is something most people have heard of but don't fully understand: the initial appearance, sometimes called an arraignment depending on the state. And this is where the clock becomes very important. Under the Fourth Amendment, if you're arrested without a warrant, the government generally can't hold you indefinitely without a judge reviewing reviewing whether there was a probable cause for the arrest. The Supreme Court addressed this in a case called County of Riverside versus McLaughlin in 1991, and the general guideline that came out of it is that this probable cause determination should typically happen within 48 hours. That doesn't mean you're released in 48 hours. It means a judicial officer has to review whether there was a legitimate legal basis for holding you in the first place. This is where a lot of the fear in this process starts to lift, at least a little, because for the first time since the arrest, a neutral judge is looking at your case. And this initial appearance does several things. The judge formally tells you what you're being charged with, you're informed of your right to an attorney, and if you can't afford one, the court will typically appoint a public defender. This right comes from the Sixth Amendment and was firmly established for felony cases in the 1963 Gideon versus Wainwright, a case that fundamentally reshaped the American legal system by guaranteeing that no one should have to face serious criminal charges without a lawyer, regardless of income. Now, here's a twist that catches a lot of people off guard. Having the right to an attorney doesn't mean one magically appears in your holding cell within the hour. Depending on the jurisdiction and how backed up the courts are, there can be a real gap between arrest and actually speaking privately with your appointed lawyer. This is part of why so many defense attorneys stress the same advice. If you're ever arrested, say as little as possible about the facts of the case until you have legal representation, because anything said in that gap can end up being used later. At this same initial appearance, the judge typically addresses one of the most anxiety-inducing parts of the entire process: bail. Bail is not designed to punish you. Legally, it exists to make sure you return for future court dates. Judges usually consider things like the seriousness of the alleged offense, your ties to the community, whether you have a prior record, and whether you're seen as a flight risk or a danger to others. Some states have moved toward reducing or eliminating cash bail for lower-level, nonviolent offenses in recent years, which is part of why bail can look completely different from one state to another. This is one of those areas where jurisdiction really does change the outcome, so what happens in one state's courtroom might look nothing like what happens 2 states over. If bail is set and paid, or if you're released on your own recognizance, you're out of custody while the case moves forward. If not, you remain in custody, and here's something that surprises people. Being held before trial doesn't mean you've been found guilty of anything. Under the presumption of innocence, a foundational principle woven throughout American criminal law, you are legally innocent until proven guilty, even while sitting in a jail cell awaiting your next court date. So now the case is officially moving through the system, and this is where a fork in the road appears, one most people never see coming until they're standing at it. For more serious charges, especially felonies, the government typically has to formally establish that there's enough evidence to proceed to trial. Depending on the jurisdiction, this happens one of 2 ways: either through a preliminary hearing, where a judge reviews evidence and testimony to decide if the case can move forward, or through a grand jury, a group of citizens who review evidence presented by prosecutors in private to decide whether to issue what's called an indictment. The federal system generally requires grand jury indictments for serious federal felony charges tied to the Fifth Amendment. State systems vary. Some rely heavily on grand juries, others primarily use preliminary hearings. Here's something people almost never realize about grand juries. The defendant and their attorney typically aren't even in the room. There's no cross-examination happening in real time the way you'd picture from a courtroom drama. The prosecution controls what evidence is shown, which is part of why the saying exists among legal professionals that a grand jury could indict, as the old expression goes, almost anything put in front of it. It's not literally true in every case, but it captures just how heavily the process leans toward the prosecution at this early stage. If the case clears this stage, the defendant is formally arraigned on the charges, meaning they officially enter a plea: guilty, not guilty, or in some jurisdictions, no contest. And this is where most people expect the story to jump straight to a dramatic trial. But here's the truth that surprises almost everyone watching this video. The overwhelming majority of criminal cases in the United States never actually go to trial. Instead, they're resolved through plea bargaining, where the defendant agrees to plead guilty, often to a lesser charge or with a recommended lighter sentence, in exchange for avoiding the uncertainty, cost, and time of a full trial. This is one of the least understood parts of the entire criminal justice system, because television teaches us that criminal cases end with a jury delivering a dramatic verdict. In reality, the plea negotiation process is where the vast majority of cases quietly get decided, often behind closed doors between defense attorneys and prosecutors. Now, if a case does go to trial, the defendant has a set of rights baked directly into the Constitution: the right to a speedy trial, protected by the Sixth Amendment, the right to a trial by an impartial jury, the right to confront witnesses testifying against them, and the right to have an attorney represent them throughout. The burden of proof rests entirely on the prosecution, who has to prove guilt beyond a reasonable doubt, one of the highest legal standards that exists, intentionally designed to protect against wrongful convictions. If the trial results in an acquittal, the defendant is free to go, and thanks to the Fifth Amendment's protection against double jeopardy, the government generally cannot try that same person again for that same offense based on the same conduct. If it results in a conviction, the case moves into sentencing, where a judge, sometimes guided by mandatory guidelines, sometimes with more discretion depending on the jurisdiction and the offense, determines what happens next. And even after sentencing, the story isn't necessarily finished, because a defendant generally retains the right to appeal, arguing that legal errors affected the outcome of the case. Appeals aren't a chance to argue the facts all over again in front of a new jury. They focus specifically on whether the law was applied correctly. So when you step back and look at the full picture, an arrest isn't just one moment. It's the very first domino in a long, structured chain of legal checkpoints: booking, an initial appearance, a bail decision, a probable cause review, possibly a grand jury or preliminary hearing, an arraignment, negotiations, and either a plea or a trial, followed by sentencing and possibly an appeal. Every single one of these steps exists because of specific constitutional protections that were fought for, argued over, and decided by real court cases over the past 2 centuries. And here's the biggest insight I want you to walk away with. The system is intentionally full of checkpoints, not because it assumes you're guilty, but because the Constitution assumes the government must prove that you are, every single step of the way. Understanding these steps doesn't just satisfy curiosity. It's the difference between panicking in the back of that patrol car and knowing with real clarity exactly what comes next and exactly what rights protect you throughout the entire process. If you ever find yourself in this situation in real life, the advice from defense attorneys is remarkably consistent. Stay calm, stay respectful, comply with lawful instructions, clearly state that you're invoking your right to remain silent, and ask for a lawyer as early as possible. Those simple sentences protect you more than almost anything else you could say. Now, if you've ever wondered what actually happens the moment police ask to search your phone during a stop and whether you can legally say no, that's a video I've already broken down in detail. And after everything we just covered, you're going to want to watch it next.